The speakers will set aside 10 minutes at the end of the presentation to respond. Now I'd like to introduce you to one of our speakers. She in turn will introduce the other panelists. Diane Mason is a trademark lawyer who consistently demonstrates a sophisticated understanding of intellectual property across a broad range of industries and technologies. A partner in Faegre Drinker's San Francisco office, Diane's more than 25-year career reflects strategic inroads into the practice of intellectual property law, with particular strength in the areas of litigation and trademarks, assisting national and international clients in developing, maintaining, and protecting their trademark portfolios. And with that, I'm going to turn it over to Diane.
Thank you, Yinhei, and good morning, everyone. Joining me today is Tor DeBella. Tor is an associate in Faegre Drinker's Washington, D.C. office, although rumor has it in a couple of weeks, he's getting brand new business cards that say partner on it. Shh, don't tell anyone. Anyway, Tor counsels clients and litigates disputes relating to intellectual property and marketing practices. Tor manages trademark portfolios of all sizes, both domestic and international, through the entire brand life cycle, from selection and adoption of a brand through registration and enforcement, and is accustomed to working closely with clients to develop cost-effective brand strategies. We're also really excited to have Adam Kaufman join us on the panel. Adam Kaufman is legal counsel at Oracle and co-chair of Oracle's MCLE committee and serves on INTA's Young Practitioners Committee. His work includes prosecution and enforcement of intellectual property rights, as well as advising clients and resolving disputes involving trademarks, copyrights, name and likeness rights, sponsorship agreements, advertising and marketing law, and regulatory compliance for promotions. So before attending law school, Adam built an international career in internet marketing and computer programming, and was responsible for over 1,000 websites and marketing campaigns involving mobile and web languages. So Adam has a lot of experience with social media promotion, and we're excited to have his input of in-house counsel role in social media ad campaigns. So let's start. So what is social media? Most of you probably know social media is typically defined as an online community that allows the creation and sharing of messages, information, ideas, user-generated content, and other forms of expression. It's estimated that at least in year 2020, at least 80% of Americans are in one form of social media or another. Globally, the average user spent 2 hours and 29 minutes a day on social media in 2020, which is an increase of an hour a day per user since 2012. In the US, the average use is 2 hours and 3 minutes a day, while 16 to 24-year-olds, it's estimated that they spend 3 hours a day on social media. Although to me, that seems on the low side during our times of sheltering in place. I just saw an estimate that teens now are spending anywhere from something like 9 to 13 hours a day on screen time. So it seems to me that teens would be spending more than 3 hours a day on social media, and probably most of us also. Social media can include, many different platforms, from blogs such as Scary Mommy or a news blog like TMZ, to business networks like LinkedIn, photo sharing sites such as Pinterest or Instagram. Now a lot of teens get their social interactions through online gamings, where they play each other on online games. And if you're a teen, you've probably heard them shouting and swearing at each other. I have these strange noises coming from my 17-year-old's room all the time. So games like Grand Theft Auto or Minecraft, people can play each other online and video sharing sites such as YouTube or TikTok. Adam, what kind of social media presence does Oracle have? And have you found some media sites better than others, or platforms rather?
Yes, so Oracle is on the various sites. So we're on Facebook, we're on Twitter, we're on LinkedIn. And we tend to find some sites better than others. One thing I want to mention is that social media isn't just limited to these platforms. We're also seeing rating sites and app stores as a new medium for social media. And those tend to be kind of preferred because they're not as open. You can't upload photos and things like that. And so when you focus on those, it seems a little bit safer. So I think we kind of focus on the ones that are a little bit safer.
So for example, what kind of rating sites is Oracle participating in?
So Gartner has a rating site, and there's some other business enterprise software rating sites. We're a B2B company, so we focus on those ourselves. But some other people I've seen in-house, work on some of the other ones. For example, restaurants would be on Yelp, and other sites that offer different types of business, more B2C, might be on some more consumer-facing sites like, some kind of business directory or something.
Great, thank you. So with so many people on social media platforms, and with so many different social media platforms out there, it seems like an ideal way to reach your consumer base and conduct an ad campaign. But what kind of issues should you be concerned about? What kind of legal issues should you be concerned about before starting ad campaign on a social media platform? One thing you should definitely be concerned about is copyright infringement. So copyright protects original works of authorship that are fixed in a tangible medium. That's a very broad category. So it can cover artwork, photographs, music, videos, anything that's kind of fixed in a tangible medium, like paper, whatever, is usually protected by a copyright. And a lot of times you don't even need to register a copyright. As soon as you create something, there is a copyright that can be enforced. Although to bring a lawsuit in federal court, the copyright owner would have had to first register the copyright in the US Copyright Office. So copyright infringement can occur if your ad content or if you encourage user-generated content to be posted on your social media account contains copyrighted material such as art, music, photos, or quotes. So a lot of times, someone will say, let's say I own Diane's yo-yo company, and I see this great picture of a yo-yo on Google. So I copy and paste that onto my Instagram account or Twitter account or whatever. I can be liable for copyright infringement. This includes, anything from memes, GIFs, third-party photos of your product or spokesperson. So even if a third party took a picture of my Diane branded yo-yo and I saw that on an Instagram account and copy and pasted and put that in my Instagram account, I can be liable for copyright infringement. Or if you encourage user-generated content, if someone, and I think Tor's going to go into this more, but if a consumer posts user-generated content, like they created a photo or they created an artwork, but that contains copyrighted, copy-protected graphics, or they just sort of blatantly copied someone and submitted it as their own work, your company can be liable for copyright infringement. So it's always good to first obtain permission or a license from the copyright owner. Don't assume that a work that's on a website or otherwise publicly available is in the public domain. So if you see something on, like if I went into Google and searched for yo-yos and got a picture of a yo-yo, just because it's on Google Images does not mean it's free for me to use. I'm going to have to figure out, who took the photo and if I need to license it or get permission from the person who took the photo or owns the photograph. It's always good to get written confirmation that the user-generated content is that person's own original work. Adam, what kind of precautions does Oracle take to make sure they're not infringing someone's copyrights?
Yeah, this is a big area of exposure. And I think part of the problem with this is that there is people who make their living off of putting photos out there. They circulate on the internet, and then it's easy enough for them to search on Google Images and find who's using that photo and then come after them. And what you can end up paying can be in the tens of thousands of dollars for some of these photos, some of these images. So at Oracle, we take a multi-tier approach. So first of all, we prohibit people from using images that are not already approved. So they have to get approval for images. But to make the second part is we make it a little easier for them by making deals with certain companies. We have a compliance program that we participate in that provides a lot of content for us. And then in addition to that, we also, make deals with media companies to provide their media, their images, videos, and other things for us to use. And then the last thing is we also have the part that I mentioned earlier, which is review. So if there's anything that's not addressed by that, then people can come to us for review and we'll review something for them. In that area, I just want to mention that you need to be wary of these free to use sites. Some of these, in the US, we have a great notice and takedown system that works very well, but it also makes it so that some sites allow user generated content to be on there, and they don't go through it to make sure that all the rights are there. They just put that burden on the person using it. So you need to be careful. Some sites will say that they're free and you can use any of the images, but all they're saying is that you don't have to pay them for anything, but there might be other rights there. So the review is all three steps, I think, are very important.
Right, and I think there was a prior question about whether there was such a thing as de minimis copyright use of a photo or artwork or anything. And I would say that if you are using any kind of copyright protected work, such as music or photo or artwork, there is for commercial purposes. So for your ad campaign, there's no such thing as de minimis use. And especially right now when, during shelter in place and COVID and high unemployment, and a lot of artists, actresses, photographers, whoever are underemployed, I think you're going to see a rise in people trying to enforce their copyrights and other rights to, just get some income coming in. And, threats of copyright infringement are very common in social media ads. And you see a lot of, okay, I'm getting mixed up. And so you see a lot of, you are seeing a rise in copyright infringement. Another area to be careful of is trademark issues. So trademarks can include anything that acts as a source identifier for your company's goods and services. So this can be a trademark, it can be a word, it can be a name, it can be a slogan, trade dress, meaning colors, packaging, content, almost anything can be a trademark if it, in a consumer's mind, identifies your company's product or services. So before launching any kind of new tagline on your social media account or using new, say, hashtags, it's good to have counsel clear your catchphrase or tagline. And even a hashtag slogan can be a trademark, and it also, the USPTO recently said that you can protect hashtags as a trademark. So unless it's your hashtag is, say, the name of your company, like hashtag Diane's Yo-Yos, or something like that, or something kind of generic like #1 yo-yos, it's good to have council clear your hashtag. It's also good if you are, say, run a contest or some kind of promotion where you're asking consumers to submit user-generated content. Make sure that that user-generated content doesn't contain third-party trademarks in the background or on signage or clothing. And this includes even like if they submit, say, a photograph and they're standing in front of a mural, this kind of going back a slide, you need to make sure that that mural, you have permission from whoever made the mural so that you're not accused of copyright infringement if you repost that. Or if someone's wearing a t-shirt with a brand name on it, like Diane's Yo-Yos or Nike or whatever, and you're not selling Nike products or Diane's Yo-Yos, the best thing to do is probably to blur that out to avoid claims of trademark infringement or false association claims. Even packaging design. So it's always good to be sort of overly cautious and paranoid in clearing user-generated content that might have other third-party trademark protected work or copyright protected work. And also, don't do a site, don't adopt a handle that might be like for Twitter or other social media accounts that might be an impersonation of someone. So for example, in 2009, the St. Louis Cardinals baseball manager, Tony La Russa, sued Twitter because someone used his name in a Twitter handle and then posted offensive tweets. So your company can be held liable for using someone else's name as an account name. Adam, any thoughts about what kind of clearance Oracle does?
Yes, so we definitely clear catchphrases and taglines, hashtags and everything. And we have strict rules about using those as well. And one thing I also want to add is, it's again a tiered approach. We don't just require people to come to us. Our team also does audits of the whatever groups we represent in order to look at all their marketing to see if they're using anything that we should inquire into. So we kind of have to do both.
Great. Another issue is rights of publicity. So right of publicity is an individual's right to control and earn a profit from the commercial use of that person's likeness, persona, or name. And so this protects against the unauthorized use of a person's identifiable attributes, such as his or her name, voice, likeness, distinctive gestures or phrases. And this is a state law governed, there's no federal right of publicity. So the laws vary by state to state. So you're gonna have to double check if you're, for various states, what they require. So for example, some states only protect celebrities' right of publicity, while other states might protect the right of publicity of an individual. And then there's also what they call dead celebrity laws, which is also governed state by state, but that protects the use of deceased celebrities' name and likeness. So if Diane's Yo-Yo wanted to, say, use Elvis in an ad, like show Elvis, say an animated Elvis playing with Diane's Yo-Yos, then I would need to go to the Elvis Presley estate and get their permission. I can't just do it because I can't say, oh, well, he's dead, so, what's the harm? And this also includes like I said, it doesn't just protect celebrities, but it can involve individuals. So one thing to look out for is even if your company got a, say, you're going to use a photograph of like Diane's yo-yos, saw a photo on Google of a little girl playing with my yo-yo. And I go to the photographer and say, hey, can I use your photograph? And they say, sure, you know, I pay them a couple $100 or something. I post it. And then all of a sudden I'm getting a demand letter from the girl's parents, because although the photographer might say, sure, you can use the photographer, unless the photographer has a release from the little girl to use it beyond what was originally agreed. So for example, if the photographer had originally taken the picture of the little girl for a clothing campaign, and that was the agreement, was the photograph was only going to be used in a clothing campaign, then the girl's parents can say, well, we didn't allow it to be used in other ad campaigns. So you need to make sure if you're using, even if you get permission to use a photograph or video or other artwork, make sure that who's ever giving you that release or license is also giving you a release for the person in the photograph that you can use that, or at least an indemnity agreement or something. So one well-known case is, this was in 2014. There was a paparazzi photo of actress Katherine Faegre coming out of a Duane Reade drugstore in New York. And Duane Reade posted that on their, I guess, Twitter account saying, love a quick Duane Reade run. Even Katherine Heigl can't resist shopping at her favorite drugstore. They immediately got sued by her for $6 million because they said, you're using her right of publicity. You didn't get permission to repost her image. So even if, maybe there's a paparazzi shot of someone or of your product on a news site, you cannot repost that. You need to get written consent before using a celebrity's picture, or person's picture, or personal attribute. Adam, any thoughts on that?
No, we do not use influencers at Oracle, but however, the owner of our company is a celebrity, and so there are sometimes celebrities. So we try to stay abreast of these issues and at least be able to advise our clients on them when they deal with it.
Great. And now I am going to turn it over to Tor.
Thanks, Diane. I hope everyone can hear me. Good morning to most of you. Good afternoon to those of you who are like me on the East Coast. For this portion of the presentation, I want to look at advertising and promotions issues that arise on social media, and that includes influencers, which is sort of a nice segue from the last slide there, Diane. I know for some of you, the word influencers conjures some excitement. For others of you, maybe a migraine, and hopefully some of the points we'll talk today about can alleviate a little bit of the stress for those of you who fall into that latter camp. And I suppose the logical place to start here is with the FTC, which is the regulatory agency principally involved in advertising and promotions issues on social media. And the two that I see come up the most in my practice are sort of encapsulated by these two bullet points here. The first of which I'll just call claim substantiation, and the second one I'll call material connections, and I'll probably say those two things a couple times throughout the rest of this presentation. So the first, tackling the first one first, brands that use social media must ensure that their advertising claims are truthful and that they have accurate substantiation for claims before disseminating them. Now, this is not a rule specific to social media. This applies with respect to all advertising and marketing in any form. So print media, traditional media, as well as sort of non-traditional or new forms of media like social media. But sometimes there are particular challenges or new challenges that arise in the social media context for claim substantiation. And the second one, and this is the one I'll focus on a little bit more today, is the material connection requirement. And that is, if there is a material connection between an endorser or an influencer and an advertiser, and that material connection, number one, is not apparent to an ordinary consumer, and number two, would materially affect the credibility of that endorsement, that material connection must be disclosed. And it must be disclosed clearly and conspicuously in accordance with the FTC's guidelines on the topic. So let's dive into the slides here and see how that actually sort of shakes out in practice. So there are a couple different ways to use influencers. And this is by no means sort of an exhaustive list. It's just the ones that you know, came to mind immediately. You know, your companies may have additional ways, creative ways to use them. There are new ways to use influencers being developed, it seems like, every day. The most common way, of course, to use an influencer is to promote your company's products or services on the influencer's own social media accounts. Sometimes you will run a sweepstakes or a promotion or a promotion including a contest or some other type of promotion, and we'll talk about that a little bit later in the presentation here. But you can use an influencer to either promote your sweepstakes or promotion on the influencer's account as well, not just your product or service. Or you can actually sort of engage an influencer to conduct a mini sweepstakes of their own, but that might, for example, give away your company's product as a prize. Another thing that I've seen a lot of companies do is something called seeding, which is basically sending free samples of the company's product to the influencer with the expectation that the influencer will say something about the product they've received on social media or whatever their influencer platform to the world is. So let's talk about what the legal rules are in cases like that. Again, the basic rule here is, if there is a material connection between you, the company with the product or service, and the endorser or influencer, and that connection would not be apparent to an ordinary consumer and would affect the credibility of the endorsement, you need to disclose, or the influencer needs to disclose that connection clearly and conspicuously. It's a rule about transparency. And the ways to do this in social media are detailed to some extent in the FTC's guidance on this issue. There are the usual sort of way that I see this done, and that the FTC recommends doing it, is with a hashtag. So hashtag ad, that is permissible to be included in the influencer social media post under the FTC's guidance. However, there are certain hashtags that are not permissible, and you see some examples of those on the screen here. Hashtag SP as an abbreviation for sponsored, hashtag partner, or hashtag thanks brand, for example, are all things that the FTC has said, these don't give enough information to consumers about the relationship between the influencer and your company, so you can't use them. And as a general rule, I like to tell my clients, if you're trying to come up with a creative hashtag that sort of masks the idea that this is actually an advertisement, don't do it, because that is the whole point of the hashtag, is to create a clear and conspicuous disclosure to the consumer. So if you're trying to think up something really, really clever, like this is not an ad, that's just not going to work. So let me kick it to Adam here. I know you have some experience dealing with these kinds of things. What are you used to seeing at Oracle in this context?
So we definitely see these types of marketing campaigns, these promotions, and you know, there is a big push, I think, along the lines of what you were saying, where they want to use certain hashtags, so like a hashtag Oracle or hashtag Oracle conference or something like that, as required for certain things. So if we run a sweepstakes, they may want to use those, and so that raises the importance of having some kind of program or requirement that they come to you. So a policy where they come to you in order to check it, so that you can compare it to the FTC guidance. and also seek help from outside counsel so that you can get the advice that you need from a law firm when they have, when these marketers have these really interesting hashtags that they want to come with, as you mentioned, trying to get away from just hashtag ad to something, clever, so to speak.
Exactly. And it's always okay to, include a hashtag Oracle or a hashtag company name in there, so long as you are also making the required disclosure that, look, this is an ad, I'm a paid influencer, or I got this product for free, or whatever the material connection actually is. That's the part that needs to be disclosed, to the viewer, if they wouldn't ordinarily assume that connection exists. So one of the things that kind of is an interesting topic that's arisen in the past couple of years is platform disclosure tools. So a lot of the social media platforms are taking it upon themselves to, I won't say do the FTC's job for them, but make it clearer to individuals on their platforms when something is a sponsored advertisement or when it is not, or alert them to these material connections. Those platform disclosure tools are good. They are always good to use, but they are not necessarily always sufficient in the FTC's eyes. It's always really important to still use that hashtag ad unless you are sure, and I can't say of a situation in which I've ever been entirely certain that the platform's disclosure tools are sufficient to meet the FTC's guidance. And in fact, sometimes in cases where a specific platform's disclosure tools might be sufficient, there are additional challenges that might not be immediately apparent. One good example is Procter & Gamble. This was, I think, either earlier this year or maybe later last year, ran a challenge for their paper towel product, Bounty. It was a challenge that was social media based that required a disclosure, and they made the appropriate disclosure embedded in the video that was posted on TikTok. But when P&G took those videos and converted them over to other platforms like Instagram, that disclosure did not also convert, and that became an issue with respect to the FTC. So things like that you might not always think of, technical issues relating to interoperability between platforms, are things to consider when you're talking about disclosures as well. Now, all of this is sort of regulated by the FTC's guidance on the issue, their endorsement and testimonial guidelines. Those, I believe, the most recent version, although I think there have been a few periodic small updates since 2009, are really the 2009 guidelines. I was listening to a talk from someone, a representative at the FTC recently, that said that guidance is being updated soon. Didn't give an exact date, but it will address social media specifically. So that's an interesting development, so certainly something to look out for. And also, I confess I didn't know this before, but in that same talk, I learned that if you do have questions about endorsement and testimonial guidelines, specifically regarding social media, you can always email the FTC's endorsements@ftc.gov email. Of course, I would use that judiciously, as if you're planning to do something anyway, you certainly don't want to be on record as emailing about it and getting an answer you don't like and then going ahead and doing it. But that's a helpful resource. One other thing I should mention is that it's not just the FTC that is the sort of relevant regulator involved here. Every state has its own version of the FTC Act, sort of captured in a state statute. Those are often referred to as little FTC Acts, or UDAP, Unfair and Deceptive Acts and Practices statutes. They're basically designed to supplement the FTC's authority over unfair and deceptive trade practices in Section 5 of the FTC Act, which is where the FTC's regulatory authority over things like this comes from. They're a little bit different. For example, they include monetary penalties. The FTC under Section 5 only has the ability to issue an injunction or a consent order, and then issue penalties if that order is violated. Not so under the little FTC Acts. Those can be enforced by state attorney generals. Sometimes they include a private right of action, and the monetary penalties can be handed out immediately. They can be anywhere from $3,000 to maybe as much as $50,000 or more per violation, which can add up if you have a big social media campaign. So influencer contracts, just in terms of influencer management, some of the things where we're often asked to draft or review contracts with social media influencers. And here on the screen, you can see a number of the different types of clauses that maybe you don't need to include, but at least should consider whether it makes sense to include in your contracts. Number one is content ownership. If the influencer is going to be creating content for you, and almost all influencers are, who's going to own that? Are you comfortable asking the influencer for your company to own that? Or is it sufficient to just have an unlimited license to use the content while the influencer retains ownership of it? Morals clauses. This is becoming much, much more important in the Me Too era, especially as every single celebrity that I see recently seems to have some sort of catastrophic, PR event happening, even those that you would never expect it with. So consider including a morals clause that allows you to end the relationship in the case of certain types of actions by the influencer. A fraudulent trigger follower or fraudulent follower trigger. It is easier and easier, increasingly easy now, to obtain fake followers on social media platforms. And any influencer agreement that relies on influencers with large social media followings should have a representation and warranty that those followers are all legitimate, and the ability to terminate the relationship and perhaps recover some of the influencer's fees if it turns out that that's not the case. Non-disparagement provision. You hire influencers because they have a significant voice, and that significant voice can be turned against you potentially if there's a falling out. So contracts, you should consider whether to include a provision like that. The right to approve, remove, and modify content of the influencer is an important thing to include. It's very rare that you'll be completely comfortable with everything the influencer posts organically. And even if that's the case 90% of the time, you want the right to change it or remove it, or ask the influencer to remove it in the other 10% of cases. FTC compliance. We talked about the material connection disclosures. The one thing I would say on this is, and I think this might be the most important takeaway from everything that I'll say today, which is I see a lot of influencer contracts that have a one-liner about this. They say, you must comply with the FTC's endorsement and testimonials guidelines. I think maybe about 3% of influencers know what that means or have ever read those guidelines. Maybe professional influencers, but certainly if you're dealing with micro influencers or influencers who just aren't that sophisticated, they're going to sign that contract and have no idea what that means. So I would recommend sort of spelling that out, especially the important points of that in the actual contract, or at worst, maybe attach a copy of the guidance to the contract as an exhibit. I think that's really important in getting the influencers to comply, which is ultimately what you want. Finally, exclusivity. Consider whether you want this influencer to be exclusive within a category for you, and how broad you want that category to be. So Adam, I know you guys don't work with influencers per se, but you have spokespeople. Any of these sort of principles that you take away and incorporate into those contracts or other types of contracts?
I think all of them definitely, except for the fraudulent follower trigger, just because we don't really work with influencers since we're a B2B company. But I think all of these are very important. One that I want to highlight, besides of course the obvious one that you already talked about, which is very important, is the right to approve, remove, modify content. I think that's really important to review things before it goes up. If you hire someone in a contract to do things for you, you want to make sure that you also have the ability to check it before it goes out into the public, so you're not liable for any of that, or even just, it can create just some bad vibes and some bad PR.
100% agree with that. And one of the tricky things to figure out on that point in influencer contracts, I mean, the power of an influencer is a lot of times to be able to respond to things in real time. So in a lot of cases, you have to make a decision. Well, do I really want to approve content before it goes? Do I want to require that? Or do I want to let the influencer post and then have the ability to remove it or edit it? I mean, sometimes if you don't have the approval right, or if you don't require approval in advance, you know, the damage can be done through a post that you have to remove later, and you might not be able to do, you know, 100% damage control. But that's sort of a decision you have to make. How much do you trust the influencer? How professional is the influencer? What kind of influencer are they? Are they sort of an edgy influencer for your brand that you might want to retain that ability, or you might want to require the influencer to submit all posts to you for approval and have those approvals be on hair trigger if you have a big enough team to handle that sort of thing? Or do you just, are you comfortable, you know, letting the influencer post organically, you know, and contemporaneously with, you know, whatever event it is in real time, and just have a team that's monitoring those? Monitoring is a really important part of this whole process. It's not enough to just have a contract in place, because you as the advertiser are responsible for all of the actions of your influencers, and the FTC views it that way as well. There was a case earlier this year where the FTC brought an action against a company called Teamy, who had done essentially everything right. They had influencer contracts in place. They had a review process in place, and it just so happened that the influencers were not complying with the material connections guidelines. And that case ended up, I believe there was it issued a penalty of somewhere in the neighborhood of $13 million, although I think that was ultimately suspended because of some inability to pay on the part of Teamy. But you're looking at big penalties. Even if you cross your T's and you dot your I's in your contracts, you have to have a monitoring system for influencers. So that's really important. Okay, so with the remaining time, we'll shift gears a little bit to lotteries, sweepstakes, and promotions. And a lot of times people look at these terms as interchangeable. They say, oh, lottery, sweepstakes, contest, promotion, they're all the same thing. Legally, they're not. A lottery is illegal to run as a private business. Only the state can run a legal lottery. So what is a lottery? It is anything that contains these three elements that you see on the screen. It contains a prize, it contains the element of chance, and it contains consideration. If you have a promotion that involves all three of those things, you have a lottery, and in 90% of cases, you're not allowed to run one of those. So what do you do? Because you want to have, you know, you want to be able to offer things with prizes that are fun or that have the element of chance. So you can eliminate one or more of these elements to make the lottery, turn it into a legal contest or a legal sweepstakes. If you eliminate the element of chance and you replace it with skill, you have a contest. And again, now you don't have an illegal lottery. If you eliminate the element of consideration, and I'll talk about that in a moment, if you eliminate that, then you have a sweepstakes. And again, you're sort of in legal territory. Now, Adam, I know that we talked about this the other day, and you mentioned a number of situations in which recognizing these distinctions is very important, but not always apparent to everyone. Maybe you can elaborate on that for us?
Yeah, so as I mentioned earlier in the presentation, marketers are very creative, but they're not as familiar with, you know, the legal standards and these, you know, these three parts here differentiated and what it is to be a lottery and not. So what we do see a lot is we see people coming to us wanting to have, you know, the chance and consideration in order to get the prize, and they kind of combine these sort of contests also, and then later from the small group of selected possible potential winners, they want to have a you know, some kind of random drawing to determine who's the actual winner. So we see a lot of combining of these elements in interesting and creative ways. And, you know, and we have to be very careful, again, about having some kind of policy in place where they have to come to us, check with us, so we can steer them in the right direction, sort of educate them and steer them in the right direction. And again, I want to also encourage people to check with your outside counsel when you have a question on these. Sometimes they can get pretty creative and very interesting and kind of raise some interesting issues.
They do get very tricky, and here are some of the issues that Adam was mentioning in terms of consideration. What is consideration? It just means something of value that's being given by the participants in exchange for the opportunity to participate. And again, if you have a sweepstakes, if you're running a legal sweepstakes, you do not have consideration. Now, what can consideration be? Well, the easiest one is money. If you're requiring somebody to pay to enter your promotion, well, that's consideration, so you don't have a sweepstakes there. But there can be other things. It's not always just money, like a payment or a donation. One of the gray areas in sweepstakes law is what's called the implied purchase requirement, which basically means you're not requiring somebody to purchase your product or service in order to participate, but they kind of have to. So, for example, if the method of entry in a particular sweepstakes is take a photo of yourself with holding my product and submit it. Well, I guess you could go to the grocery store and not check out and take a photo of yourself holding the product, and you wouldn't have to pay for it in that case. But in 95% of the cases, people are going to just buy the product. So there's a question as to whether that constitutes consideration. A conservative approach would say yes, it does, and you wouldn't want to do that either if you're running a sweepstakes. Likewise, anything where there's a considerable effort is expended. If you're visiting a store, some states look at store visits as consideration. There have been a lot of, I've seen on social media, scavenger hunts, like going places and looking for things, even using augmented reality, using an AR feature to post a photo of yourself on social media at 10 different locations across your state. Things like that can get into that gray area. So what do you do if you want to require these things? You want to require somebody to pay to enter, or you want to have an implied purchase requirement? Well, one thing you can do is you can have what I abbreviated here as AMOE, which means alternative method of entry. So you can say, well, folks, there are two ways to enter my sweepstakes. One, you can pay $5, or two, you can send a self-addressed, postcard to this address for free, or you can enter online for free. Pick one. And as long as the alternative method of entry is afforded what's called equal dignity with the pay method of entry, meaning that the folks can enter as many times with the AMOE as they can with the other method, that's fine. That's perfectly fine. But if you say, oh, well, you can donate $5 to get 10 entries, whereas you can only enter for free once, that's not okay. That's still going to run into issues. And I want to leave time for questions since I see a couple of them coming in here. So I'm going to just go quickly through some of these other requirements here. When you are running a sweepstakes, keep in mind some have registration and bonding requirements in certain states, particularly New York and Florida. You want to have an official rules. Whenever you advertise the promotion, you want to have a short form rules at the bottom of all of your advertisements or included somewhere. You'll recognize those. They say things like, no purchase necessary to enter or win. Sweepstakes begins on this date, ends on this date. Odds of winning vary depending on number of eligible entries received, etc. If you have a large prize, you might want to require the winners to execute releases, ensuring that your company is not liable for any issues associated with the administration of the promotion or the issuance of the prize. I want to touch on just very quickly here, surprise and delight. I've been seeing more and more of those, which is if you just surprise your customers with some prize or some award just for being a good customer, and you don't advertise it in advance, and they have no way of knowing it's coming, you don't have a method of entry, for example, it's just, hey, it's Christmas or it's a holiday, I'm going to give 10 random customers a free product of mine without advertising it in advance. That does not create any issues, and you don't have to worry about sweepstakes and promotions rules and regulations because you're not encouraging people to enter. You're not driving business, you're just doing it. The last one I want to kick to Adam here because I know you have some interesting thoughts on that. Co-branding and co-promotion. All of this stuff is very easily done when you or your company is the only party involved in setting up the promotion. But what if there's more than one party involved? That can create some tricky issues.
Yes. before I get into that, I would just want to say that we're seeing the surprise and delight a lot more. Those seem to be becoming a lot more popular now, especially since they don't have to, go through the rigorous legal requirements and everything to do that. About the co-branding and co-promotion, marketers, again, very creative. They come to us and they want to do these. A lot of people have called them so-called joint promotions, or a joint contest or something like that. And what it really is there's going to be the co-branding on there, or there's going to be some sort of promotion where we're delivering the prize and the other person's running it. And I just want to mention that what we've kind of steered our clients to is to making sure that these just have basically one owner. So one person who's the sponsor, who's the organizer, who's responsible for it, and then the other person is just participating in that they're delivering a prize, or they have some kind of deliverable to that they're offering, in order to have someone who's kind of responsible for everything, make sure that everything's intact, and the other person doesn't have to worry about that. So we don't want to jointly hold these. We don't want to have some kind of co-branded situation where we're responsible for it. We typically will have the other person as organizer, or we'll be the organizer of it, and then that they just kind of deliver the prize or something, and we can mention that.
Good point. I want to pause here and do a little bit of a lightning round on some of the questions that have come up, because I think those will be helpful to people. And a lot of them have to do with consideration. So I'll just take a couple of them here. The first one I see is, what about filling out a survey? Is that considered consideration? Does it depend on how lengthy the survey is? It could be, but in general, I would say you're probably pretty low risk in the survey category. I mean, if we're talking about a consumer satisfaction survey that a customer fills out after having an experience with your product or service, which is what I see most often in this context, generally that's not enough to rise to the level of consideration. If it's like a research survey that takes a couple hours to complete, you could be getting into a gray area. But that's kind of how I would view that. It has to be a pretty long survey to really be sort of risky as consideration. Someone asked if for the alternative method of entry, can it be emailing your info to an email address? Yes, that's fine. That's a free method of entry that wouldn't constitute consideration. One thing to keep in mind when you're asking people to provide personal information that I've seen businesses run into from time to time is what you're using the collected information for. So for example, if you are going to ask someone to provide you with their email address as part of entering a promotion, a sweepstakes or contest, and then you're going to give that to your marketing folks, and they're going to blast these people with 1,000 marketing emails, there is an issue of consent and whether the purposes for which the email address was initially provided, that is, to enter into a sweepstakes or promotion and presumably to be notified if they win, whether you're exceeding the scope of that consent by using the information for other purposes. So just be careful of that. And if you are planning to have your, add this to your customer databases for marketing purposes, just make sure you provide sufficient notice to entrance of that in advance. Say, look, we're going to collect your email for X, Y, and Z purpose. And that way you don't run into those types of issues. Someone else asked about asking people to like a post and then follow the social media account. Is that consideration? So this is a really good question. This is and there's a very nuanced answer here. So you might be familiar with the term like gating, which is a term, I actually don't know who coined it, but it was a big issue on Facebook a while ago, which was Facebook prohibited the practice of like gating, which as I understand it, which was requiring people to like a particular page as a condition of entry into a sweepstakes or promotion. However, I do not believe that the prohibition on like gating prohibits, and I'm not sure about this, but this is how I've always understood it. I do not believe that prohibits folks from liking a post, a specific post on a page. And the distinction there is because liking a particular post, it's obvious if you're reading the post that folks are required to like to enter a promotion, that this is why they're liking it. This is why this post has 1,000 likes. If you read the post, it says, like this post for a chance to win. However, that's not obvious if you're just liking a page. If you're trying to artificially inflate the number of followers for your company page or your company brand, That's the kind of thing that I think the light gating prohibition that Facebook and some other social media platforms were getting at in establishing that prohibition. So I would just say that it's not consideration. Requiring somebody to like is something that's free and it's very easy to do. It's a separate issue that has to do with Facebook's or the social media platform's own rules. And that's something important to consider here. In fact, that's the next slide. And I'm going to pause in just 1 second and kick for questions, since I think we're getting close to time here. But you will see here a number of platform specific rules. These are independent of all of the state rules on sweepstakes and promotions. If you're running a promotion on social media, you have to abide by the legal rules, of course, but you also have to abide by the platform specific rules. And each platform has its own rules. For example, Facebook and Instagram require a disclaimer in your official promotion rules that Facebook and Instagram are not affiliated with a promotion, and that each participant absolves Facebook and Instagram from any liability. There's the light gating promotion that I've got in the second box there. And one where I see folks get jammed up all the time is actually these third and fourth ones. Facebook prohibits tagging friends to enter as a condition of entry. It also prohibits requiring folks to share things on their own personal timelines, which I see time and time again, but is technically against the platform rules. And one thing that can happen, and I've seen it happen on platforms, is if Facebook gets wind that you're violating their own platform rules, or any social media platform for that matter, they can shut the promotion down. And that creates not only a practical problem or a PR problem, but it also creates a legal liability problem, because now you have a sweepstakes that was halfway done that's shut down. And how do you administer the prizes? How do you select the winners? All of those things that you're required to do under the law once you've started a promotion. So that can get into some tricky issues, which we will save for another day here, because we're at time. So with the remaining minute or two we have left, I guess I want to pause. I'll kick it back to Diane and maybe get a question or two in.
Thanks, Tor, and thanks, Adam, for your insights. And I think if people have any further questions, we can stay a little bit longer to answer questions.
Yeah, I had a question. I was wondering, is there anything that is improper if you have a promotion where there's the first part of it where you attend a webinar, and then the first 100 people who attend the webinar get a gift or a random drawing after the webinar, and then there's a second, and then if those people who attend the webinar agree to taking a meeting with the holder of the promotion, they get another gift. So basically, you have a kind of a random drawing and a somewhat low consideration. They have to actually meet with you to get the second gift. Is that improper?
So yeah, just talking about those two pieces in turn. The first one is, I would say, equivalent to a random drawing. So it would be a sweepstakes. And this is again, a little bit of a gray area. But I have always viewed first 100 people to show up, get a free whatever it is, as essentially a random drawing, because there's no skill involved in showing up first. It's just random chance. So I would treat that as the sweepstakes. It's not, depending on what they're showing up to. If it's just a webinar, I would not say that's consideration. So you're okay. You don't have to provide an alternative method of entry, but you should treat it as a sweepstakes. Make sure you have the rules set up, et cetera. For the second part, that's where the consideration issue comes in for me. If you're requiring a meeting in order to win a prize, that could be construed as consideration. Would depend on sort of the specifics of that, but I think that's again one of those types of non-monetary consideration that is significant enough to sort of rise to the level of maybe it makes sense to include an AMOE here as well. I will say that in the last 20 years or so, as far as I'm aware, no regulator has enforced the consideration issue over non-monetary consideration. It's always been monetary consideration that has been the issue. So, view that however you'd like, sort of in terms of the risk of that. But I will say it's always been a live issue, and it's always hotly debated in academic circles about sweepstakes and contest law.